Now, first off, for today, we are just going to continue, but this is going to be the big number 3. There was an act committed, but I'm not criminally responsible for what happened. I did it, but I was insane when I did it. Now, I'll be the first one to say, looking at these people that we just saw, I would say probably the only option you have is to go with insanity. Kind of like what I was saying before, where you go, these are not the actions of a sane person. These are the actions of someone who is insane. But proving insanity is really difficult. Now, there are kind of 2 avenues that you can go down. 2 attempts to show that your client's insane. First thing is you can say, this person, when they committed this act, didn't know what they were doing. Their state of mind was such that they can make the argument that they couldn't have done it because they were not in a state of mind that allowed them to do so. Now, I will give you just this example here because I've heard this in multiple court proceedings. If you're trying to prove insanity, you need to look at a jury of sane people and convince them, my client was not like you. He was insane. Now, the example I give, the one that I've heard multiple times, is the defendant says, and this is almost a quote, I think, would say, I was not even in my body when that act was committed. I saw it happen, but it wasn't me doing it. I was like floating above my body watching it happen. Now, I'll go ahead and ask you guys. Does that sound insane?
Yeah, definitely.
Sure. Is it hard to kind of wrap your mind around the idea of, oh, I didn't do it because I was watching myself do it? Well, okay. That's kind of the groundwork that has to be laid out here. Now, I give you that example so that I can give you the second one here. The other thing that you can go, the other avenue to take, is you can say that your client didn't know right from wrong. They were unaware that what they were doing was bad. Now, I say this because maybe, who knows, it's up to the jury. Maybe this one's a little easier to wrap your mind around. Now again, who really knows? Because both of these are hard for a sane jury to ever agree to. But I want to ask you, do you know who this is? I guess I'm not surprised. This is Andrea Yates. Her case was probably, about 15 years ago, I guess now. Andrea Yates was a mother of 5, and she was a stay-at-home mom. And one day her husband came home from work, and she was just greeting him at the door, and she said, something's wrong with the children. He goes, what's happened? She goes, I don't know, just come in. And all 5 children are laid out on their bed, dead, because she drowned them in their bathtub. Now, she had never had any history of mental illness, nothing like that. The police show up, they find the dead children, and they arrest her, and they said, why did you do this? And her response was basically, what did I do? And the police have this statement where it's really kind of creepy the way that she's operating because she's just blank. She just doesn't know anything. And the police are kind of looking at her saying, you killed your children. And she said, I would never do that. I don't know what you're talking about. They take her away, they arrest her, and now it's time for her day in court. Now I need to ask you guys, does that sound insane?
Mm-hmm.
Sure. This is kind of the ultimate problem, though. If you're going to prove insanity, you got to prove that this person, in their mind, had no idea what they were doing. And trying to prove that to a jury is really, really tough. So you're going to need to bring in some experts. Now, let me kind of ask, if you want to have an expert on sanity, who are you bringing in? Who do you say?
Psychiatrist.
Gotta have a psychiatrist. So the defense is gonna hire their psychiatrist. Now again, let's play it out here. The defense psychiatrist is gonna say what? Especially in her case. Who do you say?
She was perfectly sane.
The defense?
Oh no, she was insane because she didn't even know what she was doing.
Sure, defense psychiatrist is gonna say she's insane. But prosecution gets their psychiatrist as well. What is the prosecution psychiatrist going to say? Not necessarily in her case, but in general. This person's sane. They're just trying to use this as an excuse. So you're going to have two psychiatrists there. One saying she's insane, one saying that she is sane. It's all a matter of who the jury believes more. Now, I'll tell you this. In the Andrea Yates case, both sides bring up their psychiatrists, and the defense psychiatrist is saying, almost like, this is a perfect classic example of insanity. She's like the icon of insanity. Then the prosecution psychiatrist gets up there, and he said, she's probably insane. How do you think the jury found her?
Insane.
They found her insane. They said, when you did this, you were insane. And you can't send the insane to prison. You send them to a psychiatric ward. I kind of forget what she got. I think she got like 15 years in a psychiatric ward. So I believe, if I remember right, she should be getting out soon. Because you can't convict the insane. Yes, sir.
What state was this? And also, can the prosecution psychiatrist say that the defense out in this instance?
Let me kind of say it like this. You're paid by the prosecution. You're paid to be there for your time because you're an expert. But if it's like a clear-cut case of insanity, you can throw some things out there that say, well, maybe she was sane if there was this, this, and this. But even that psychiatrist said, look, in all my area of expertise, yeah, she's insane. I don't think anyone could say she wasn't. Now, the insanity plea is hard. It's real tough. If I could put a number on it, I'd say for every 100 insanity pleas, you maybe get one. Maybe one person's found not guilty by being insane. It's possible, but it's tough. Now, I want to talk about some other ones. Other defenses that are out there, but are basically purely based on age. You can say, I did it, but you can't convict me because of what's called infancy. Now, infancy is just completely based on how old this person is. If you're younger than 7, as a society, we're not charging you. We're not convicting you. It's not going to happen. It's not what a civilized society does. So if you are under 7, you can legally not be charged with a crime. I had someone I think it was like 2 years ago now, where he goes, I have a little brother that's 6. Can he rob a bank for me? And I said, yes. Yes, he can. But when he's caught, because the 6-year-old's not getting away, you know what he's going to say?
My brother told me to do it.
My brother made me do it. So then what do you charge the brother with?
Accomplice.
Conspiracy, maybe even accessory, and now you got to deal with mom. You got all sorts of problems. So please, if you need to write this down, don't have your 6-year-old brother rob a bank. Okay, that's the lesson for today. Now, there's going to be more of a gray area in the next kind of defense. The next one can be infancy, but if this child is between the ages of 7 and 14, they can be charged. Now I say can because probably not, because you are presumed to be incapable of committing a crime. So again, let's kind of play it out. I have a little brother that's 7. Can he rob a bank for me? Again, probably not convicting a 7-year-old. What about the little brother that's 14? Can you charge and convict him with a bank robbery?
Maybe, but not good.
You can, but it's going to be real tough. So in order to address issues in an age range like this, we have almost like a parallel justice system. We have a juvenile justice system. So if you rob a bank at 14, yeah, you can be tried, you can be charged, but you're probably going to be tried in a juvenile court. Where if you're convicted, you're not going to prison with the adults. Probably not going to happen. You're going to go to a juvenile detention center with other children of this age range. Now, can you be charged as an adult if you're, say, 16?
Yeah.
Sure.
I'm big enough.
It's possible. Will you be? Probably not. What about 17?
Maybe.
Maybe. Depends. What about 18? Poof. You no longer have this option. The day you turn 18, you're an adult and you play by adult rules. In one day, it all changes. Now, I want to talk number 3 here. The intoxication defense. Now, I always like explaining this one because very rarely does this work. This is almost never a valid defense, but it's possible. So I want to kind of set up a scenario here. If you are so intoxicated that you have no idea what you're doing, and you commit a crime, is it your fault? It's your fault, of course. You can go into court and say, Your Honor, I was so hammered on whiskey that I didn't know what I was doing. How do you think that would go over in a court? Wow, really? I don't care. You did it, you're guilty. Now, I want to explain how this defense can work. It's possible that if you can prove I was so intoxicated, I didn't know what I was doing, and it wasn't my fault, then you have a leg to stand on. Because that shows that you didn't have the mental states to commit the crime. Now again, let me go back to my little example. You go into court and you say, Your Honor, I drank so much whiskey I didn't know what I was doing. Is it your fault? Yep. So how could you say, I was intoxicated, but it wasn't my fault? I didn't do it. What do you think? Oh, what do you think? That's a valid defense. I didn't even know what I was doing because someone put that in my drink. That's a possibility. What about like leaving a doctor's office? Like say you had some kind of surgery and they put you under, you come out after the surgery and the doctor goes, Here are your keys, go ahead and drive home. And you get into a car accident. Was the intoxication your fault? Not necessarily. You can say, it wasn't me, it was the doctor that did that. That's possible. Now again, I would very much never advise someone to use this. That's not going to go well. Now, I just want to cover the last few, and in order to do that, I think I'll be okay on time here, but I just want to let you know, the last few are a little bit complex. So I think the best way to explain these is via example. Next one we're going to talk about is what's called the entrapment defense. Now, entrapment is even listed out in your constitutional protections. Entrapment says, I'm not guilty of this because law enforcement set me up. I wouldn't have committed that crime, but law enforcement made me do it. Now again, entrapment is kind of hard. It has to be done very sort of specifically if you're going to say law enforcement made me do it. So I will give you this example because this is what the Supreme Court uses as their example. This happened in the 1960s. There was a guy who was convicted of child pornography. Now I think if I remember, he got convicted in like the 40s or 50s. He got convicted, sent to prison. He was in prison for like 15 years and got out. The police in that area said, this guy's going to do it again. We got to get him back in jail. So they sent him like these little cards in the mail.